And after going through the types of companies, we also went through pre-incorporation contracts, the common law position, and the modification of that position by the Companies Act, where the common law's position is that an entity that is yet to be born cannot have an agent, which was expressed in the case of Kellner versus Baxter. But that position has been has been modified by the Companies Act, which seeks to indicate that pre-incorporation contract is also acknowledged. However, a company, once the company comes into operation, may decide whether those transactions that were entered preceding their incorporation, they will ratify or not. That is, accept responsibility or not. That was what we did last week. And so today we shall continue with other activities, and then the focus basically will be on what we refer to as the veil of incorporation and lifting of the veil of incorporation. And so that should be the focus of our discussion today. I'm trying to see. Course rep called me the other time saying that some of the notes that I forwarded, you couldn't download. And so I want to see if it is here, then I'll forward it to you again. Okay. I think the history is here. Please, I hope you also read about, we also did something about names that companies can adopt and the processes, and how such names can even be modified and the rest. We went through all of them. To the veil of incorporation, and then we can look at membership and other. Okay. I have the veil of incorporation here. So just a minute. Let me forward the history to you. So at least you have everything. Okay. Try to see if you can download the history. So one of us should open the app for us.
Yes, please. I've been able to download.
Okay, that's good. So one of you should open the act, the Companies Act, which is on the page. Okay. Now, when we talk about the veil of incorporation, let me confirm on the course outline. Just a minute. That's lecture 5. Sorry, lecture 4. So please, download lecture 4. After which you look at lecture 5. Please, you have it? When you check the page, you see lecture 4.
Yes, sir, we have it.
So open lecture 4. I want you to take about 5 minutes to glance through yourself, after which I will come in. Just some 5 minutes to glance through. Okay. I hope you've been able to do that. Now, if you recall the meeting we had last week, and we were talking about the advantages of having a company. One of them was the separation of the owners from the people that manage the company. It is on this same assumption that the veil of incorporation is based on. Now, they say that the people that incorporate the company are distinct from the company itself. And so once, assuming Felicia, Lisbeth, Stephen decides to incorporate the company and name it Felicia Company Limited. Even though Felicia, Lisbeth, Stephen were the people that incorporated the company, as soon as the company becomes incorporated, that is the Felicia Company, it also becomes an entity, a body on its own. And that body is different from Felicia, Lisbeth, and then Stephen. What it means is that the entity Felicia Company Limited can be sued. And so if I think that the company has done something against me, even me, I can sue the company. Felicia can sue that same company because once it is incorporated, it is seen as a body distinct and separate from the people that incorporated it. And that is what we refer to as there is a figurative veil once the company is incorporated that separates the company from the people that incorporated the company. And that is when we can talk about the veil of incorporation. For us to better appreciate it, I want us to consider the case of Solomon versus Solomon and section 18 of the Acts. So the person who has been able to open the Acts, please you open to section 18. Section 18. Please, who is there? Section 18. I want someone to read for us. And I'm downloading the case of Solomon versus Solomon and forwarding it to you.
Section 18, Powers of Companies.
Mm-hmm.
Subject to this act and to any other enactment, a company shall have a full capacity to carry on or undertake any business or activity, do any act, or enter into any transaction. And B, full rights, powers, and privileges for the purpose of paragraph.
Okay. Now, I now have the case, Solomon versus Solomon. Now, let me read the facts of the case. Solomon transferred his business of bootmaking, initially run as a sole proprietorship. I hope you are following. So, assuming I have a business, which was sole proprietorship. So, you know, the businesses that are being run in town, majority of them are sole proprietorship, are run on sole proprietorship. So, I transferred the business to a company which I created, Solomon Limited, incorporated with members comprising himself and his family. The price for such transfer was paid to Solomon by way of shares. And so I started my small business I transferred the ownership of that business to the company. And so what I was doing with my sole proprietorship, like Felicia has started a business of selling items by the roadside. The business is booming. Then Felicia decides to set up a company. And in setting up the company, Felicia was a member of that company. The husband was a member of that company. And the children were members of that company. And so the business that I was doing, I sold it to the company, which I have created, Felicia Company Limited. The price that the company was supposed to pay was in the form of shares, which gave me shares, and that made me become a part owner of the company. So the price for the transfer was paid to Solomon by way of shares and debentures. And so shares and debentures. So assuming the amount involved in the sale of the sole proprietorship by business was 20,000. The 20,000, 10,000 was issued in shares, and 10,000 was also issued by way of debenture. Debenture, in the sense of company operations, is a loan that you have given to the company. Shares makes you become part owner of the company, but if they call the security debenture, it is like the company has borrowed from you. So in this case, Felicia sold the company 20,000 to Felicia Company Limited, and they gave Felicia 10,000 in the form of shares, and they acknowledged that Felicia, you are owed 10,000. But who formed the company? Felicia. Who are the owners of the company? Felicia and the children. But we have Felicia Company Limited that has indicated that Felicia, we owe you 10,000 in the form of a floating charge. And if it's secured on some assets of the company, a loan will you have to provide collateral security. So the company provided the assets of the company as collateral. Later, the company's business failed and it went into liquidation. And when it went into liquidation, it's like the company wasn't doing well. And so it got to a point where the company's assets were less than the liability. The liabilities of the company exceeded the assets. Now, in doing so, Felicia now says that, company, you owe me 10,000. You need to pay my 10,000 to me. I don't know if you are following. I hope you are getting it.
Yes, sir.
The company
Yes,
that
sir. Yes, sir.
okay.
Yes,
So now the company is into liquidation. The company owes Felicia, and I hope you know Felicia. Felicia is the one that started the company. That same company owes Elizabeth, and that same company owes, let's say, Dominic. Now a liquidator has been appointed. So the liquidator told her, but you, Felicia, you are the same person that started this company. You are the same person that's transferred your business to this company. Elizabeth has contributed money. And if the company's assets can only pay one, why don't we pay Elizabeth? Because you, Felicia, and the company, you are the same. And that was when the court came in to say, once the company was incorporated, Felicia at this point became distinct from the company. So if the company owes Felicia, and per the arrangement of the loan, Felicia is to be paid first, regardless of how much is left. If the company pays Felicia and there's nothing to pay Elizabeth, so be it. And it was in that case that the principle of separate legal entity was addressed in that particular case. And that is what we mean by the separation between the company and its members, and or the figurative veil which separates the company from its members. There's also another case, Lee versus Lee's Air Farming Limited. Lee versus Lee's Air Farming Limited. And that case also talks about that any rights, obligations, liabilities of a company are discrete from those of its shareholders. So what it means is that if a company owes or have a liability, and I'm a shareholder, the liabilities of the company is distinct and they have to honor. Regardless of me being a shareholder, if the company owes me, you cannot say that being a shareholder in the company, we are one. No. The fact that I'm a shareholder does not make me the company, and that the company is distinct and separate. And that is where, as a shareholder, you enjoy the limited liability. If it is a company limited by a liability, it means that your liability, the only thing that you are supposed to pay to the company, if you owe, in the case the company is winding up, is the amount which you owe on the shares. And if there is no such amount, and the company rather owes you, regardless of the implication, the company will have to pay you. So in the Felicia Lisbeth case, Felicia started the company, and the company owes Felicia, and the company also owes Lisbeth. But the amount involved could only pay Felicia, and after paying Felicia, there will be nothing left. So the argument of Elizabeth and co was that you and the company, what is the difference? Is it not you saying Felicia that started this business and turned it into a company? But the law also saw that once Felicia turned the business into a company, the company became distinct. And in that regard, if the company owes Felicia, and after paying Felicia, nothing will be left, that obligation has to be honored. And it is similar that the similar case, a similar decision was also held in the case of Lee versus Lee's Air Farming Limited. Understood? Understood?
Yes, sir.
Yes, sir.
That is what the section 18 is talking about. And so you realize that it says that the company will have full capacity, just like a human being, to undertake everything, full rights, powers, privileges. So the fact that you are a shareholder does not mean that you will be dictating to the company what the company should be doing, because the company is regarded a full human being. And so whatever the company wants to do, the company can go ahead and do it. However, there are instances, and that is where we talk about exceptional cases, where the court will think that no, if we allow us to continue, then the likes of Felicia, who started the company, can hide under the company and do a whole lot of things. And so there are instances that the law will say that no, for this we cannot hold the company. Let us find out who are those behind all the atrocities that the company has been committing. And so once the court says that we are ignoring the separate legal entity principle, and we are going to identify the people that started the business so that we can deal with them instead of dealing with the company itself, then we are moving into the realm of what we refer to as lifting the veil of incorporation. Now, I'll use UCC as an example. You see, you can take an action against UCC. When you take an action against UCC, it is UCC that has to represent. So if you see the Vice Chancellor in court, the Vice Chancellor is not UCC, but the Vice Chancellor is working for UCC. But if you want to say that UCC do not have math, it works through people, and looking at what has been committed, you want to deal with the individuals. You cannot straight away deal with the individuals. The law requires you first to pierce the veil of incorporation, also referred to as lift the veil of incorporation, so that we can know who are the people in UCC that have been misbehaving towards you. That is when we can see, so we have the Vice Chancellor, Professor Nelson, and Professor Buampo is there. Okay, there's a Pro VC and there's a lecturer called Dominic. These are the people. That is when you can bring an action directly against me. But until you lift or pierce the veil of incorporation, if you are suing thinking that it is me that you are suing, your action is not directed towards me. It is rather directed towards the investee. That will appoint a lawyer to represent itself. And so the investee has a lawyer. So lawyer Solomon Fache will come in and say, when they mention the case between Felicia and UCC, who are the representatives? Then the lawyer for UCC will say, I am representing UCC. Felicia's lawyer will also rise to say, I am representing. But when you lift the veil of incorporation and decide to assign responsibilities to the individuals, then when the matter is called, it will not be you against UCC, because at that time, the veil of incorporation has been lifted. It rather becomes you against the individuals. And that is what we refer to as the veil of incorporation. Understood? Are we okay? So
Yes,
what
sir.
are the instances that the veil, which we spoke about, can be lifted? There are two ways of doing so. There are two ways of doing so. Please, a minute. I want to share the screen. Okay, I went off better back now. Okay, so we have the statutory and the judicial instances by which the veil of incorporation may be lifted. So you look at each of them. The statutory inroads, instances by which the veil of incorporation be lifted so that we can deal with the individuals. Someone can read section 8.1 of Act 992. Section 8.1. Section 8.1. Section 8.1. Someone should read that for us.
Okay, sir. Section 8.1. Companies limited by guarantee.
Okay.
1. A company limited by guarantee shall not be incorporated with the object of carrying on business for the purpose of making profits other than making profit for the furtherance of its objects. 2. Where a company limited by guarantee carries on business for the purpose of making profits other than one of the furtherance of the objects of the company, the officers and members of the company who are cognizant of the fact that the company is so carrying on business are jointly and severally liable for the payment and discharge of the debt and liabilities of the company incurred in carrying on that business. And the company and those officers and members are each liable to pay to the registrar an administrative penalty of 25 penalty units for each day during which the company carries on that business. 3.
Good. Okay, continue.
The total liability of the members of a company limited by guarantee to contribute to the assets of the company in the event of the company being wound up shall not at any time be less than the amount of money specified in the application required for incorporation.
Okay,
4.
that's okay. That's okay. That's okay. Now, our focus is on section 8.1 and then 2. When you look at section 8.1, you remember when we were talking about types of companies, we said that the company that cannot be established to trade and make profits is a company limited by guarantee. So assuming the company decides to do business that makes them make profit other than businesses that allows them to provide the charitable services. That is what the 8.1 and 2 is referring to. Then the court is indicating that if by the statutory provision is indicating that when some of these things happen, we will not say that the company is distinct from the members. We will lift the veil, identify the people who are hiding behind the company to do things against what the company was incorporated to do. Then we will deal with them. And that is when they are talking about they will be liable for the payment and whatever of debt to the registrar of the company and the administrative penalty that they are supposed to pay. So the statutory inroads we are referring to instances that the Companies Act itself can lift the veil of incorporation and punish individuals. And one of them is provided for under section 8.1. Are we okay? And 2. Are you okay with that?
Yes, sir.
Yes, sir.
We can also look at section 6 and section 41. So someone should look at section 6. Another person should look at section 41. So the one that is section 6, can you please read to us?
Section right to form a company.
Yes.
One of or more persons may form an incorporated company under this act.
That is okay. So another person should also read 41. So the section 6 is saying that one person can establish a company, can form a company. I hope that is clear. Now let's read section 41.
Companies
If
ceasing to
at
have
any time a company ceases to have a member and it carries on businesses without at least one member, every person who is a director of the company during the time that it so carries on business is jointly and severely liable for the payment of all the debts and liabilities of the company incurred
Okay,
during
so
that period.
very good. That is jointly and severally liable for the payment of all the debts and liabilities of the company incurred during that period. And so you read the 6 in combination with 41. That is when you will understand that the law says that you can have a company with one member. But when you realize that there is no member and you operate the company at least for a period without even one member as acknowledged under section 6, then every director of the company during the time that it so carries on the business would then be asked to pay, would be severally liable for the payment of all the debts and liabilities of the company incurred during that period. So in that case, you cannot say that it was a company. The veil will be lifted, then that director who was supposed to have ensured that the company had at least a member to conform with section 6 and failed to do so would then be personally held liable for any debt that may be incurred during that period. Understood?
Say,
Please
good morning.
understood? Yes.
Say the 6 and the 41,
Yes, please.
where you are talking about directors, where you realize that for some time and there is nobody. I want you to clear that side a little.
In
The
terms of
in terms of lifting the veil.
uh-huh. Okay. Section 6 says that you must have a company of at least one member. Is it understood?
Yes, that is
Okay.
understood, sir.
So the membership of a company has to be defined. Maybe then you will understand what we mean by members of a company. To define the membership of a company, I want us to look at section. Let's look at section 33. Let's look at section 33. It's something that we will be doing today, though. But to be able to explain and to be able to appreciate what the section 6 and 41 and the lifting of the veil talks about, then we need to first understand what is in section 33. Now, very good. So we are defining who the members of the company are. And you will get to know that membership is distinct from directorship. So you can be a director of the company, but it does not make you a member of the company. So if you are to be considered a member, and the company is supposed to operate with at least one of these as a member, then we are looking at subscribers to the documents for the incorporation of the company. So when we go through the processes leading to the incorporation of the company, remember last week we spoke about it, where you'll have to prepare documents which must conform to some requirements. Then you submit it to the registrar. Then the registrar, if it's satisfied, will issue you the will issue the certificate of incorporation. Those people that are signatories to the document that is submitted to the registrar, you are referred to as a member. And so if at the time of incorporation, your name was captured as a member, having subscribed to the regulations, you are considered a member. The second category under Section 33(1)(2), Section 33(2) is that any person who agrees with the company to become a member and whose name is entered in the register of members. So if you are looking for members, we must see that your name is in the register. And then 3,
A member has the right, duties, and liabilities that are by this act and where applicable by the registered constitution of the company conferred and imposed on the members.
So I read subsection 5.
A holder of a share is a member of the company.
Okay, so that is okay. So if we are looking for membership of the company, we are looking at Section 33(1), 33(2), and 33(5). Now, in relation to the question that you ask, where the company operates without a member. So what we are referring to is that the company is operating without a single member, as defined under 33(1), 33(2), and 33(5). That is when the veil of incorporation will be lifted, then the directors will be dealt with. Is it understood now?
Yes, sir. Yes, sir.
Okay. So the way you are asking me questions, exams, I'll ask you similar questions too. Because I'll ask you to, with reference to decided, explain the separate legal entity principle. That is why I want you to make reference to the case of Solomon versus Solomon, lease versus lease air farming. That is what we use in explaining the separate legal entity principle. And when you go through your notes, you see Morocco versus Kuma. That is what we also use to explain the Ghanaian position on the separate legal entity principle. So the A part will be explain the principle of the separate legal entity principle. B, explain 4 instances each under which the veil of incorporation may be lifted. And so that is when you now come in that the veil may be lifted under 2 circumstances, that is by the statutory provisions and by the courts, as we witnessed in statutory and the judicial. And so under the statutory, we have mentioned 1, Section 8(1). We have also mentioned Section 6, 6, and then 41, which you ask the question for us to go to 33(1), 2, and then 5. Is it understood?
So,
Yes, sir.
I want to ask, so in an attempt to answer, are you
Yes.
supposed to make references to the sections?
In an attempt to answer.
Yes.
If
Answer, yes. Are you supposed to make reference to the sections stipulated in that?
you are not lawyers, so you will not ask you of the authority. But how do you, for example, if you say that the veil be lifted, where a company where a company limited by guarantee operates for profit, I will mark you. That is an A. Another person says that Section 8(1) and then goes ahead to indicate the company limited by guarantee operating for profit. That is also A, but that A is excellent. And your A is very good. So we have 80 as A. We also have 90 as A. And we also have 100 as A. So the one that they do not mention, you have your A, but that A is 80. Another person will also get 90. And that same person will also get an A. But in the end, all of you have gotten A's. Are you okay now?
Yes, no.
Okay, so what I'm interested in is for you to be able to indicate those instances and indicate that there are some statutory provisions. And so once you say statutory provisions, Fine. If you don't remember those provisions, but remember the content. So where a company operates without a member, I will mark you. There is also section 21 and then section 125. And they will also look at section 171, 1 and then 2. So can someone help us go through these sections together? So somebody should open section 21. Another person should also open section 125.
Section 21.
Okay.
Section 1. The last word of the name of A. Private company limited by share shall be limited company or the abbreviation LTD.
Very good.
B. Public company. Should I proceed, Doc?
Yeah, proceed. Okay, so 21. 21 says that if you say you are limited by shares, it must end with the abbreviation LTD. If it is a public limited liability company, it must end with the PLC. And that is why of late GCB says they are GCB PLC. Backlist PLC. Now, someone should read 125 because you have to read the two together to understand what you mean by the description of the company. 125, 2 and 3.
Where a company default in complying with subsection 1, the company and each officer of the company that is in default is liable to pay to the registrar an administrative penalty of 250 penalty units.
Very good. So I hope you've seen it. So you are supposed to have LTD at the end, and you failed. 125 is saying that such a company, once you fail to do what is right, and it goes ahead, such a company is in default of what has been prescribed. Then in that case, you'll be subjected to pay this fine. And that is where we will now ask the directors who were hiding behind the legal facade. That's the veil of the corporation to perpetuate those crimes will be asked to make that payment. Understood? Please, are you okay?
Yes, sir.
Let's also look at 171. Who has been able to open it?
Number of directors. 1711. A company incorporated after the commencement of this act shall have at least 2 directors, one of these directors being ordinary resident in Ghana. 2. If at any time the number of directors is less than 2 in contravention of subsection 1 and the company continues to carry on business for more than 4 weeks after that time, the company Say, please, I'm coming. Okay.
The company, the director, and each member of the company that is in default is liable to pay to the registrar an administrative penalty of 25 penalty units for each day during which the company so carries on business after the expiration of the 4 weeks without having at least 2 directors.
Yes. Yes. The
So-
screen went off.
Sorry. So it is also telling you that just like the company must always have 1 member, the company must also have at least 2 directors. So if you operate with less than 2 directors, you have contravened Section 171. And that is where the 1712 comes in and imposes a penalty on those directors who should have known better and was supporting the company to perpetrate those acts. Please understood?
Yes, sir. Sir, please, I have a question.
Please kindly ask.
Okay, so, sir, the Section 171,
Yes, please.
1 and 2, if
Yes.
I understand, is indicating that here, when the veil of incorporation is lifted,
Mhm.
they will fine you.
Yes, please.
Okay. Okay. All right.
So,
Thank you.
so what it means is that once it is lifted, then those responsible for the commission of those acts would then is liable to pay to the registrar the administrative penalty. And the penalty is for each day that the wrong continues. So you'll be paid until you correct it. And 25 penalty units, I think the penalty units are around 12 cities or so. So you multiply the 12 by, so every day that the wrong occurs. Are you okay?
Yes, sir. Yes, sir.
Now we can
So,
move on. Yes, please ask the question.
so say if every day and we are not getting another director,
Mhm.
so what do we do?
Then you must cease to operate. Then you are not supposed to transact any business. You get it?
Okay.
You are not
Yes.
supposed to engage in any, because if you do, you are rather exposing the other party to some of these risks. The risk is that if the business do not succeed and they bring an action against the company, you will say that this company, they don't have directors. So you rather was doing things at your own risk. But in this case, to avoid that, that is why there will be, you impose fine on them. And if I do business with such a company, when the director knows that they will operate illegally, then I can lift the veil and deal with those individuals if there is any debt that is accrued, or if there's any debt that may be accrued. Please, are you okay?
Yes, sir.
Okay. We continue. Section 32.123. Can someone help us with that?
Thirty-two. A company shall, upon request of a member, send to that member a copy of its registered constitution on payment of the fee prescribed by the company. 2. Where an amendment is made to the registered constitution, each copy of the constitution issued after the dates of the amendments, and whether to a member or to any other person, shall be in accordance with the amendments. 3. Where a company defaults in complying with this section, the company and every officer of that company that is in default commits an offense and is liable on summary conviction for each offenses to a fine of not less than 25 penalty units and not more than 50 penalty units.
Okay, so you see another instance by which the law lifts the veil of incorporation to deal with it. Are you okay?
Yes, sir.
Okay. So that is the first part. where we spoke about the statutory provisions. So if I ask you to explain the veil of incorporation and make reference to some decided cases, you should be able to. And indicate 4 instances by which the veil may be lifted by statutory provisions or by statute. Then you are supposed to make reference to all the statutes that you have made reference to. So from section 8, from section 6 and 41, section 21, adding to 125, 2 and 3, section 171, 1 and 2, and section 32, 1, 2, 3. Are we okay? There has
Yes.
also been some judicial decisions. Which has also led to the lifting of the veil of incorporation for liabilities to be assigned to the individuals, members, and directors of that company. And so, what are some of these judicial inroads? There we need to look at. One of them is where you treat the company as a mere facade. You can see facade, F-A-C-A-D, but the C, you can see there is another sign. So we call it facade. Others will say mere facade, but facade. Now, that is where a company is formed, but they conceal the true facts, which essentially means that it is formed to avoid a pre-existing obligation or matters that borders on fraud. So there are some companies that do that. Today they are companies so and so. Then the next time they turn it to another. So when you bring an action against them, they say, no, we are not the ones that transacted with you. That was Company Felicia. But we are no longer Company Felicia. We are Company Elizabeth. So it is Company Elizabeth knows nothing about what you are talking about. And so when Company Felicia metamorphoses into Company Elizabeth, and the view is that we want to avoid obligations, then the veil will be lifted. And those people who were responsible for that can be dealt with. And there are some cases that will help in addressing that. We have the case of Jones versus Lipman, Clifford Motor Company Limited versus Horn, Amate versus SSB Bank Limited and others, Odd versus Belhaven, Crazy versus Richwood Motors. All of them are cases. And today I'll give you an assignment. The assignment will be that you have to Google some of these cases, know the content of the cases, so that when you are reading, you will understand what they really mean. Are you okay?
Yes, Doc.
The second one is when you treat the company as an agency. When you treat the company as an agency. So when you say the company is an agent, then where is the principal? So when an action directed towards you, you say we are just agents. So the principal has to deal with it. And so you cannot create a company to operate as an agent of another company. And so there are some instances. And then that is where you can look at the case of Smithstone and Knight Limited versus Birmingham, Adams versus Cape Industries PLC, Kumi versus State Gold Mining Company. And you can also talk about NHN Food Distributors versus Tower Hamlets. You can read around that case too. For public policy too, the veil may be lifted. And that is when you can look at the Daimler Company Limited versus Continental Tire and Rubber Company Limited. And in the interest of justice too, the veil may be lifted, and there are some cases under it. Akoto versus Akoto, Moko versus Kuma, and versus Cape Industries, and then in A Company. So your responsibility now is to search for the cases, read the facts of the cases so that you can understand those instances so well. But as for me, I have one full question for you this morning in exams. That is coming in exams. Explain with reference decided cases, explain the veil of incorporation and indicate two instances each where the veil may be lifted under statutory provision, then under under statute, and then judiciary. So I'll make it 4-4 for 20 marks. So I've gotten you another question. Don't tell me areas again, because that is a question I'm going to ask. Add this question to the questions that were asked last week, so that when you are learning,
Please again.
hey, because I said that I have this particular question, I have said it more than 3 times on this page. With reference decided cases, explain the veil of incorporation. That is A. Explain 4 instances each by which the veil of incorporation may be lifted under 1A, statutory provisions, and then 2, judicial decisions. Or I can limit you to only the statutory provisions. You get it?
Yes, Doc.
Yes, Doc.
So if you ask me areas and I tell you I don't have any areas, don't say I am a difficult person. I am not. Okay?
Yes, Doc.
Okay, so we can then move on to the second topic for the day. And as we did last week, we normally give ourselves some 10, 15 minutes break so that you can go and get your cocoa to eat, after which we continue to 11. So we can have our break, and then at 9:10 or 9, latest by 9:15, we resume the second part. Or do we continue?
No, Doc, let's break for a while.
Okay. So let's do that and resume as we have all agreed upon. Okay.
Thank you, Doc.
Okay, so we are coming back 9:15. Thank you.
Thank you, Doc.
So good morning. We are back once again. You now look at membership and the company secretary, and then probably next week we look at auditors, directors, and then we can also look at securities. And if there's still space, we can then consider issues of liquidation and related matters. Then we can end our semester. Hopefully, next week will be our third meeting. Then we'll be left to the last meeting, and then we would also we'll look at the issues that I've mentioned. Then we can bring our discussions to an end. For the membership, we need to look at what we read earlier on section 33. Section 33. So someone should help us with that one. So you can read, the slide is also on your page. Members of a company and company secretary.
So members of a company. The subscribers to the document for the incorporation of a company are members of the company, and upon incorporation shall be entered as members in the register of members referred to in section 35. 2. Any other person who agrees with the company to become a member of the company and whose name is entered in the register of members is a member of the company.
Okay, so we can simplify what you've just read to say that you can become a member of a company, 1, by subscription, 2, by agreement, and 3, by shareholding. And so either you subscribe to the documents at the time of incorporation to be a member, and upon incorporation, we enter your name as in the register of members, or you agree to be a member and your name is entered into the register of members, or you buy the shares of the company, and that makes you a member of the company. If you remember the 33.5, you can become a member through shareholding. Are you okay? And so when you are asked to explain membership of a company, we have by subscription, by agreement, and by purchase of shares. So this morning you've gotten another. Explain the membership of a company with reference to section 33. Explain the membership of a company. So your notes will say by subscription, by agreement, and by purchase of shares. And if you are to explain, then you will explain what you mean by subscription, what you mean by agreement, and what you also mean by purchase of shares. And so once you hold shares in the company, it makes you a member of that company. And so membership continues until, and that is where we are now moving into the termination. So
Sir,
you are, yes, please.
So, sir, I just want to clear small ignorance here.
Okay.
I want to verify those who subscribe to the document and those who agree to be members of the company. Don't they pay any amount to be part, or just by subscribing and then agreeing?
It depends on the arrangement you have for your name to be entered. It is just like the normal associations that you form. Some come by paying membership dues and their names are entered into it. Others also join by just agreeing, like what you normally do in your church. You form an association in church and then your pastor wants to become a member. Do you take money from your pastor to become a member of your society?
No, we don't.
but you enter the name of the pastor as a member of that. And so what it means is that your pastor agreed and subsequently you entered the name. So it does not necessarily mean that the person may have to pay something. It depends on the arrangement. But in most cases, if you want to, then you should have made some commitment towards that. But it does not necessarily mean that everybody. The only instance by which you have to make a contribution is by the shares. That one, without the purchase of the shares, you cannot. And that requires you to make some contribution. So by agreement and by subscription, it does not necessarily require you to make some payment, but you cannot say same with respect to subscription, by the purchase of shares. Are you okay?
Yes, sir.
Okay. So we can then look at if you become a member by shareholding, you continue to be a member until you transfer your shares. What it means is that, assuming you transfer your shares in company A to me, you cease to be a member of company A. I become a member of company A. And so to you, you are no longer a member of company A. But me, because I purchased those shares, I become a member of company A. Then we continue. And so we are looking at the termination. And so you can look at section 6, A, B, C. And then you can even add the 7. That is where you talk about how membership of a company may be terminated. And so one of them is section 6A, subsection 33, subsection 6A. When you transfer the shares, that is one of them. And the second one is the shares are transmitted by the operation of law to another person or forfeited for non-payment of cost. Now, let me explain the operation of law. The operation of law is assuming you have filed for bankruptcy. Per the filing of the bankruptcy is an admission that you are no longer responsible to hold assets. So once you filed for bankruptcy and you were holding shares in another company, the filing of the bankruptcy allows the state to take over the shares and allocate those shares to another person. And that also is an indication that you, the person, by the operation of the law, you cease to be a member. Assuming you are also involved in criminal activities and the state finds out, the state can, through the operation of the law, take over those shares and assign the shares to any other person. That is also an indication that you, the person involved in those legal activities, you cease to be a member of those companies that were holding shares. And that is by virtue of the operation of the law, which the state took over and assigned those shares to someone to take charge on behalf of the state. And at times too, you indicated your intention to subscribe to the shares, to say you wanted to buy 20,000 of the shares. And upon several attempts to get in touch with you, you decided not to. And another person shows an interest, we can give the shares to that person. And failure to pay for the shares, you also forfeit them, which allows us to transfer the shares to another person. Then the third one is when the member dies. When the member dies. However, membership of a company limited by guarantee continues until the member dies or validly retires or is excluded from membership. So this explains. So in one breath, you can be asked, explain the membership of a company and indicate how membership of a company may be terminated. Then you should be able to explain up to the subsection 7. So what are the rights of members? Section 34. If we're a member of a company, what rights are you supposed to enjoy? Someone should read section 34.
Right of member to attend and vote at general meeting,
Very good.
1. Subject to subsection 2 and subsection 52, a member has the right to attend a general meeting of the company and to speak and vote on a resolution before the meeting.
So it is a right you have to enjoy. So it is a right you have to enjoy. Once you are a member of the company by virtue of section 33, 1, 2, and then 5. That is by subscription, by agreement, and by purchase of shares. You are entitled to attend all meetings of the company. You are also entitled to receive notices. So 34.2.
Despite subsection 1, a registered constitution of a company may provide that a member is not entitled to attend and vote at a general meeting unless the cost or any other sums of money presently payable by that member in respect of shares in the company have been paid.
Okay, this is also talking about instances that the company itself, by virtue of their own regulations, will say that to avoid instances where people will not pay up shares that they are subscribed to or they subscribe for, you cannot attend the meeting until you have. That is an arrangement that the Companies Act allows you to do to ensure that anybody who has subscribed to the shares of the company pays or makes sure it is fully paid for. And that one, the law allows it. Understood?
Yes, Doc.
Okay. So you realize it's not whatever it is. The things we are learning are not difficult at all. Or are they? Are they difficult?
So they are not difficult, but sometimes when they come to the exams, that's where we get confused.
You are at least you have taught for some time now. If you learn very well, should it be a problem? There shouldn't be any confusion. Anyway, it wouldn't be anything difficult. All that I will expect from you: read, learn. Normally, I give tutorial questions from which I select from, but for your batch, the tutorial questions are the ones I read to you every week. And I'm going to pick 5 of them as your end of semester questions. 4. Then there will be objectives, and then there will be 20 objectives. Is that the case?
Yes, Doc.
And then there will be 40 section B. So out of the 40, I've given you the when we met last week, I gave us some questions, and this week too, I've given us some questions, and these are the questions that I'm going to ask. That's all. So at least you have your 2 questions to answer, and going forward, depending on the things that we do, we add on to them. So out of all these numerous questions, 4, it shouldn't be a problem to you. Okay.
Okay, Doc.
Okay. Yeah. So let's continue. Section 34, the 2, which you just read. Now let's look at section 35.
Subject
Talks
to,
about register for members, so you can continue.
okay, so subject to the Central Securities Depository Act 2007, Act 733, and any other enactment, a company shall keep in the country a register of the members and shall enter in the register A, in respect of members of the company. AI, the names and addresses of the members, and in the case of a company having shares, a statement of the shares held by each member and of the amount paid or agreed to be considered as paid on the shares of each member and of the amount remaining payable on the shares. II, the date at which a person was entered in the register as a member.
Okay. So I think I have to move something. I have to move one of the slides to okay. So rise of members, I think it's been simplified here. There is also another right attached to the register. So when you look at 36, which allows members to inspect the register, and they provide for the period that members can inspect the register. So when you look at the except when the register of members is closed in accordance with section 37, the register, the index of the names of the members of the company, the index of whatever shall be open. And then they provide the hours by which they will be open. And if you want to even get a copy of it, the instances under which you can get a copy. It is a right that the member enjoys. So you can add that one to the right to inspect the company register when opened, and the right to even request for a copy of the register upon the payment of the approved or agreed fee. All these things are part of the right. And when you go through the entire act, there are several of such acts. There are several of such acts. And then there are several of such acts that gives members some rights to undertake certain activities within the company. So long as they arise, there are also liabilities. When you enjoy rights, you must also enjoy liabilities. So liabilities, I think last week we spoke about some of them. If it is a company limited by shares, your liability is if you, at the time of winding up, you owe any amount on the shares, that is the one you'll be asked to pay. Then we talk about a contributing, where a contribution has become due and payable in accordance with Section 1, and the terms of the agreement with the company, the member has undertaken personal liability. It goes on and on and on. So the liability of members continue, where they talk about present and past members, they talk about contributors. All of them are indication of how much you'll be required to pay. If it's a company by guarantee, what will be your liability? The amount you pledge to contribute to the assets of the company before being admitted to become a member of the company. So once you go through that, that is it. And remember Section 41, when the company ceases to have a member. Remember, we read Section 41 in combination with Section 6. And that was when we said you can have one member. But where you do not have any member and you continue to do business, that is when the company and its officers will be severally and jointly liable for the payment of the debts and liabilities of the company. At this point, let me pause. If there are questions, you can ask. So that brings to an end our discussion on the company membership. Please ask your questions. So before, remember, I have given you an assignment to lifting the veil of incorporation under the judiciary. All the cases listed there. You are supposed to brief the cases, search for the cases, and let me give the assignment properly or formally. All the cases listed under lifting the veil of incorporation by the judiciary, you are to search on the internet and address the following. One, the facts of the case and the ruling or the decision of the court, and how the ruling decision of the court helps in addressing the lifting of the veil of incorporation. So that is something that you yourself you add, and that will help you to have a better understanding. Yes, sir.
Can you read the second part of the question?
So I'm reading from my head, so I've not written it down. So you are to do an internet search of all the cases, and A, write on the facts of the case, and 2, the decision or the ruling of the court in the case. That is B. And C, how the ruling, the decision helps in explaining the principle of piercing the veil of incorporation or lifting the veil of incorporation. Please take note of the words. If in exams you hear or you see the word piercing, it is still referring to lifting the veil of incorporation. If you see the word inroads, 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 it is also talking about instances that the statutory provision judiciary also lift the veil of incorporation. So please take note of these vocabs so that at any point when you see any of these appearing in your exams, you don't say these were nomenclature weren't used in class, and so it creates confusion on your minds. We've mentioned them in class, so I'm at liberty to use any of them to ask the questions. Are you okay?
Yes, Doc.
So that is the assignment. So once we are okay with the assignment, we can then, and we are done with members. So you know who members of the company are under Section 33. You know the rights of members, you know the liabilities of members, you know the consequences for a company not having even a member. You know the company is supposed to keep a register, and as a member, you have every right to inspect. And you also know that if the company is to keep the register, the arrangement in the register, when you read on Section 33, coming up to 36, it talks about the keeping of the register. That's 35 is the register and how the register is supposed to be kept and everything. The content have all been provided under that. These are things that you can read on your own. I don't expect you to know everything there. And that is why you have the act. So at any point in time, you can make reference to it. So let me pause here. If there are questions, you can ask. If there are no questions, then we can continue with the secretary. And if there's still time on our side, we address the issue of auditors. And then we move on. Then next week, we can then look at directors. And then we can as well turn our minds to security of the company, where we look at shares debentures. It is a little bit technical, but it's not something you wouldn't be able to. Then we can, in our last meeting, look at issues of liquidation, which I'll give out as an assignment for which you do a presentation in class for me. At least I must hear you speak small. You two speak some. Okay?
Yes, Doc.
Okay.
Yes, Doc.
So questions for me?
Doc, the question was about, it's not a question though. I had a major challenge when you were giving the assignment in regards to how you're going to work towards it.
It's a reading assignment.
It's
It's a reading assignment. Yes. You know, as students, when you say reading assignment, you don't attach punishments or rewards to it. They don't take it serious. So all that I was saying is that you are to do an internet search on all the cases that we mentioned when we looked at instances that the veil of incorporation may be lifted under the judiciary. So once you do the internet search, first describe the facts of the cases that you search, the ruling of the cases, and thirdly, how the ruling of these cases help in explaining the principle of separate legal entities. That was all. Are you okay? Have you gotten the question?
Yes, Doc. Yes, Doc. Thank you so much.
Okay, you're welcome. Okay, so our next is to look at the company secretary, who is also a very important personality when it comes to the affairs of the company. And every company must have a secretary. And so let me direct you to we look at please a minute. We can look at section 211. Let's look at section 211. Section 211 to section 213. Sections 211 to 213. Someone should open, and then we're going to focus on that with respect to company secretary. So please, let's turn and open to sections 211 and 213, so we can look at the company secretary.
Section 211.
Okay.
Company secretary. A company secretary have a company secretary. A company shall have a company secretary who shall possess the qualification specified in subsection 3.
Okay.
The company secretary may be a body corporate, except that the body corporate must have as one of its promoters, subscribers, directors, or operating officers a person who is qualified to be a company secretary. 3.
Okay. Wait, let me explain it. So the 2111 is talking about the company, every company having a company secretary who must possess some specific qualifications required of a company secretary. And the qualifications have been provided for under subsection 3. And that's when they talk about has obtained a professional qualification, a tertiary level qualification that enables that person to have the requisite knowledge and experience to perform the functions of the company secretary. Has held office before the appointment as a company secretary, trainee, or has been articled under the supervision of a qualified company secretary for a period of at least 3 years. Is a member in good standing of the Institute of Chartered Secretaries and Administrators or the Institute of Chartered Accountants, Ghana, having enrolled. So every company must have a company secretary. The qualifications that you must possess has been specified under the subsection 3. And they are saying that you can have another company providing secretarial functions to the company, and that is what the subsection 2 is talking about. And it says that assuming I establish a company to provide secretarial services for your company, one of us must be a professional secretary who meets the qualifications mentioned under subsection 3 prior to the incorporation of that company that is being incorporated to provide secretarial services. Is it understood?
Yes,
Are
Doc.
you okay? Yeah. So if you want to perform the work of a company secretary, then you must focus on section 211, subsection 3, and try to get the requisite skills and expertise specified under the 3 before you can perform the work of a company secretary. Understood?
Sir,
Yes,
please,
Doc.
sir, please,
Yes,
a
madam.
little clarification on the 2.
Okay. The 2 is saying that was what I was explaining. You can get another company performing the functions of a company secretary. Do you get it? So assuming I can establish a company, and the purpose of my company is to provide secretarial services to other companies. But the law says that if I want to establish a company, that will be providing secretarial services to your company. And so it means that I am the secretary. So if you are referring to the secretary of your company, it is another company that is providing that secretarial services. And it's saying that for such a company, you must have one of your members at the time of the when promoting the company, prior to incorporation. One of the members or one of those promoters must have or must meet the conditions specified under the trade. And so when you read the two well, it says that subscribers, directors, operating officer, a person who is qualified to be a company secretary. And for someone to be qualified to be a company secretary, it has been provided for under 2113. So it means that if I want to establish a company, then one of us who will eventually be members or directors of that company, we must meet the qualifications provided for under subsection 3. Are you okay?
Yes, please. Thank you.
Understood now?
Sure.
Okay, continue. Let's continue the reading. 3. So read 2113 because we are reading 211 to 213.
The directors shall not appoint a person as a company secretary unless that person A has
So
obtained.
relax. So all of us on the platform, if we have any plans of becoming company secretary, then we have to listen carefully, so that after school we can get these additional qualifications, which allows us to practice as company secretaries. Okay, so continue.
A has obtained a professional qualification or a tertiary level qualification that enables that person to have the requisite knowledge and experience to perform the functions of a company secretary.
Continue.
B has held office before the appointment as a company secretary trainee or has been articled under the supervision of a qualified company secretary for a period of at least 3 years. C is a member in good standing of I, the Institute of Chartered Secretaries and Administrators, or II, the Institute of Chartered Accountants, Ghana. D, having been enrolled to practice, is in good standing as a barrister or solicitor in the Republic, or E, by virtue of an academic qualification or as a member of a professional body, appears to the directors as capable of performing the functions of secretary of the company. 4.
Okay. So you can continue. You read the 4.
I read the E, so I'm now moving to the 4.
Yes, you can read the 4 as well.
4. For the purposes of paragraph A of subsection 3, a professional or tertiary level qualification is a discipline with an offering in company law practice and administration. 5.
Okay.
Unless the constitution of a company otherwise provides, the company secretary shall be appointed by the directors for the term at the remuneration and on the conditions that the directors consider fit, and may be removed by them, subject to the right of the company secretary to claim damages from the company if removed in breach of contract.
So let's pause here. So who have the right to appoint company secretaries per what you just read?
So the directors.
That's all. So the directors have the right to appoint and remove, provided in the removal of the secretary, they are not in breach of the contract, which will entitle the company secretary to sue for damages if they do so and breaches the contract under which the secretary was appointed. Now read the 2116. It is also one of the instances by which the veil of incorporation may be lifted.
2116. Where a company carries on business for more than 6 months without a company secretary, the company and every officer of the company that is in default is liable to pay to the registrate an administrative penalty of 25 penalty units for each day that the company continues to carry on business without a company secretary after the expiration of the period of 6 months.
So in your notes, instances under which the veil of incorporation may be lifted, add section 211, subsection 6, where a company operates without a secretary for a period of 6 months, for more than 6 months. Add it to it. Are you okay?
Yes, Doc.
Add that. Please add it to so that you get more points. So when I ask you to explain 4 or 5 instances, don't say in the notes you had only 4. We have added another one to it. Now let's continue. There's 7.
7. An act required or authorized to be done by or to the company secretary may, if the office is vacant or there is not for any other reason, a person capable of acting as company secretary, be done by or to an assistant or a deputy company secretary or any other officer of the company appointed by the directors to be acting company secretary.
Okay.
8. The company secretary
sorry. Before you move on, let me explain. So where the position is vacant, remember the power of appointment is with the directors. So then they can make an arrangement. If there is a deputy secretary, if there is no such person, then the directors can appoint someone to act in the absence of the company secretary so that that position cannot be said to be vacant. Now, before one will accept to work as a company secretary, that is where the 211 subsection 8 talks about that you must agree in writing before assuming office. And once you agree in writing, the consent to serve must be transmitted to the registrar. So without this, if they appoint you and you start working without having a written consent to serve as a secretary, then you are working illegally in that establishment. The law requires you to indicate consent in writing, which it is the responsibility of the company to forward to the registrar. And so kindly take notes. So now we know that the company must have a secretary. We know the qualifications that the company secretary must have as provided for under section 2113. And we also know that if there is a vacant position, either the deputy comes in or the directors will appoint someone to do so. And before you assume the role of a secretary, you must consent in writing. And that must be given to the company, who must ensure an onward transmission to the registrar. You must fulfill your requirement by consenting in writing. If that one is fulfilled, it is now the responsibility of the company to transmit that to the registrar. So if you fail to do it to the registrar, the company do not have a secretary because you have not completed the requirement that enables the company to have a secretary. And the requirement is that consent given to the in writing given to the company and onwardly forwarded to the company registrar. Understood? Now, what are the duties of the company secretary? And that is where we will turn our attention to section 212. And remember, I can ask you this question a question on company secretary, where I will ask you who qualifies to be appointed, explain the processes leading to the appointment, or explain the following: appointment and qualification of company secretary. Then you are supposed to explain the qualification. How is the company secretary appointed by the directors? And before assuming office, must consent in writing and those things. That addresses the appointment. But the qualification one comes under 2113. So what are the duties of the company secretary? Any other person to read? Duties of the company secretary.
So should I continue?
Yes, please. But I wanted another person to take over. You have read for some time.
Okay.
Please, you have read for some time, so let's allow another person to take over. Someone who has not read today.
So I'm reading.
Have you read today, or this is your first time?
It's my first time.
Okay, then you meet the criteria. Please, you okay.
Duties of a company.
The secretary, okay?
Okay.
Okay.
Duties of a company. Pardon?
So, company secretary, what are your duties? Tell us.
Okay. The duty of a company secretary include A, assisting the board to comply with the constitution of the company and with any relevant enactments.
Let's pause
B.
here. Please,
Okay.
you take your time. As you read, we explain. So,
all right.
This is one of the reasons why people have this misconception that a company secretary must be a lawyer. But per the qualifications that we read, it does not make it mandatory for a company secretary to be a lawyer, even though having a law qualification is good or gives you another advantage per the provisions under 211 subsection 3. Your duty is to assist the board. And it could happen that none of the board members knows law. So you are the right-hand man to the board, right-hand person to the board. And that is when you must ensure that whatever decision the board is taking is in compliance with the company's own constitution and any enactment that regulates the activities of that company. That is a critical responsibility, because if you, the company secretary, mislead, you may misdirect the board into a ditch. And there may be some consequences for failing to perform your duties. And it is one of those instances that can even lead to your dismissal, which the board of directors can easily do because they have the power to appoint and the power to sack you. B.
Keeping the books and records of the company.
So all the registers you are supposed to keep, all the books that are supposed to be kept by the company as prescribed by law, it is the registrar who is supposed to have custody of these. And I'll try and see, there's an essay question somewhere. I'll try and get that particular essay question, and I will ask you. It relates to company secretary. I'll try and get it. I'll try and get that question if I recall. Or I'll try and see if I can phrase an essay question on company secretary, which will allow you, by the time you finish answering, you should have written everything under 2111 up to the 8, 212, and then from 211 to 213. You would have written everything there. Because at this level, I expect that you'll be able to do so. Now, the C.
Ensuring that the minutes of the meetings of the shareholders and the directors are properly recorded in the form required by this Act.
And so one of the key functions of the secretary is the writing of minutes. And writing of minutes is critical, and it must be done in a way as prescribed. Remember, minutes of the company secretary is critical and can even be used as evidence in courts when there is any dispute. And so you don't take writing of minutes for granted as a company secretary. It is something that you must pay critical attention to. Let's continue.
Preparing and issuing out notice in the name of the company.
Very good. So what it means is that before any meeting can be held and any other thing, you shall cause all notices to be given. Normally, it is the board. So a sample you see is the company secretary issuing out the notice, but will write under it by the authority of the board, meaning that not on his own. And this particular provision is talking about the company secretary doing so in the name and has to be authorized by the board of directors to do so. Understood?
Yes, sir.
Let's continue.
Ensuring that the annual financial statements of the company are dispatched to every person entitled to the statement as required by this act.
Okay, please continue.
Ensuring that all statutory forms and returns are duly filed with the register.
Okay, so going forward, you see a number of returns that the company secretary is allowed to undertake or perform or file. And that becomes a responsibility of the company secretary. And as indicated here, once we get those ones, you get to know. And then as a company secretary, you also know that it is part of your core duties or mandates to undertake those activities. Continue.
Maintaining the statutory registers of the company.
So one of them is the register of members, as we went through under 33. You remember? I hope you remember. So it is one of those registers that the company secretary is supposed to maintain. Continue.
Providing the board with guidance as to the duties, responsibilities, and powers of the board, and on the changes and developments in the laws affecting the operation of the companies.
Okay. Yes. Okay, continue.
Informing the board of legislations relevant to or affecting meetings of shareholders and directors and their failure to comply with the legislation, and reporting accordingly at any meeting, and advising the directors on their responsibilities as directors.
So when I ask you to explain the responsibilities, the duties and responsibilities of company secretaries, you should be able to do so. And remember that company secretaries, modern company secretaries, are not scribes. I hope you know what scribes are. They expect you. Oh, when you say you are a scribe, you are just writing. But per the readings that you have read, our company secretaries just scribes or scribes. They do more than that. So I can ask you an essay question. Modern company secretary is more than a scribe. Discuss. Explain. Then you should be able to tell me that per the provisions in this act, a modern company secretary does more than just scribe, because scribing is the minute part. But if you look at the other provisions, assisting the board to comply with the constitution, keeping the books and records of the company, preparing and issuing out notices, ensuring other all those other functions that perform makes the company secretary an integral part and must be someone knowledgeable and not just a mere scribe. And that is also affirmed by the qualifications provided for under section 211, subsection 3. And these things goes to indicate how important the company secretary is. And it is a function that cannot be performed by any mere person. It was in the past that we thought that company secretaries were just scribes who would just write, typewriters, they just type, or they were just those kind of people. But from your reading, they do more than that. And that makes them very important in the affairs of companies. Understood?
Yes, Doc.
Yes, sir.
So we can continue. Let's look at 213. Then we'll jump to 215.
Avoidance of acts in dual capacity as directors and company secretary.
Now, let me explain. Please hold on.
Okay.
This portion is talking about instances where a company secretary may work in a dual capacity. That is, we may appoint the director as a secretary, and that's why we refer to that director as an executive director. And when you are supposed to sign a document in both capacities, you can only do so in one, and you cannot do so in dual capacity. And that is what the 213 talks about. So you can read it now.
Where a person acts as both director and company secretary of a company, a provision requiring or authorizing an act to be done by or to a director and a company secretary shall not be considered as done if the act is done by or to that person acting in both capacities.
As I was explaining, you can do so in only one capacity and not in both capacities. Understood?
Yes, Doc.
Okay. So you can also talk about the 214 fine, the calculation of the remuneration and how they are supposed to pay taxes. You can talk about the 215. It talks about the register of directors and company secretary. You can also talk about registration of particulars of directors and company secretary. And all these, remember we spoke about the documents that you are supposed to file with the registrar. All these are part of the documents to be filed with the registrar. And the company secretary is expected to play key roles in addressing those concerns. Are you okay?
Yes, Doc.
Okay. So I think that would be okay for company secretary for now. If I think we still have some more time, we can add other tests to it, or you are tired.
So let me ask a question.
Okay.
Okay. So say directors appoint company secretaries. And then in one of the duties of a secretary, the director who appointed the secretary is coming to advise the director on his or her responsibilities.
Yeah.
Yeah. How?
Oh, so
Who is appointing you don't know my responsibilities.
I'm coming on. I'm coming. I will not take you far. Who marries you? Who married your wife for you?
I did.
I hope when they advise you don't take it. Does it mean that you know more than your wife is the one to tell you what to do, or you don't know what to do as a married man?
It's duty there.
So I hope you get it. It is not when that is why you go to school. As you are advancing in your academics, you realize that you are not a repository of all knowledge. That is when you acknowledge that your knowledge is limited to a particular area. And so you also need someone who has a knowledge in other areas where you have a limitation. And that is where the person comes in to support you so that you're able to perform your work well. It is just like how the president appoints ministers. The ministers that are appointed may be expertise in their areas. And that is where they can advise the president on certain matters that can be done. And the president can also direct them when it comes to asking them to undertake certain activities on their behalf. Like, for example, a company is supposed to hold a meeting. The directors will then order the secretary, you need to put out. But where, for example, you are supposed to hold your first general meeting or you are supposed to hold an annual general meeting, the company secretary are supposed to keep tabs on the period that such meetings are supposed to be held. So where the directors have overlooked, that is when you draw the attention, please. This year, you've not had an annual general meeting, which is against the law. And so we need to. Then okay, then the director can then cause you to send out notices meeting the requirements of law, how notices are to be sent for the company to hold the annual general meeting. Understood, please?
Yes, sir. Yes, sir.
Yes, Doc.
So you are okay now. Now, when you go home, go and tell your wife that I married you. You cannot advise me, and see if there will be peace in the house. Anyway, so if we are not tired, we can add one more. But if we are tired, then we can consider that at least we've covered enough. Then we can add auditors to it. We can add auditors to it, and then or what do you think?
Yes, Doc.
Let's
We can.
We can add that auditors.
Yes, sir.
Yes, sir.
Okay, let me stop sharing this, and then let's add auditors to it. To whom much is given, much is expected. Don't disappoint me.
Yes, Doc. We won't.
I've heard you. I'm now going through to send the notes on auditors. Okay, I have the auditors here. I think, I don't know if I forwarded this one to you. Let me send it to you. Let me put it on your page. Let me put it on your page.
Sir, please, is it Auditors 2021?
Yes.
I think we have it all.
Okay. So I've also seen directors. We can add directors to it. Do you have directors on your page?
No, sir.
Okay.
Oh, please.
I'll add directors to it. So we've done that of company secretary. I think constitution. We've not done the constitution of the company. Let me send that one to you as well. Okay. I think we've covered almost everything now. So let's look at auditors. And so let's look at section 138. I think we can even start from 137. You can start from 137 and then you'll be looking at auditors. 137, which talks about the auditor's reports. And then 138, which talks about the qualification of an auditor. And then the 139, which talks about appointment of an auditor. And then we can look at remuneration of an auditor, 140. And the removal of an auditor, which is also another examinable area. And then functions of an auditor. So we can look at 137 to 143. All of them talks about auditors. So someone can help us. So we go through together. Let me share the slide. Auditors.
Okay.
Who qualifies to be appointed an auditor? Let's look at 138. Qualification of an auditor.
Qualification of an auditor. 138, section 1. A person is qualified for appointment as an auditor of a private or public company if that person is A, qualified and licensed in accordance with the Chartered Accountants Act 1963, Act 170, and B, not disqualified under subsection 2.
Which you'll be going to go through. So who is disqualified from appointed as an auditor? So who is disqualified?
Yeah, someone who has not who is not a professional chartered accountant.
No, please talk like a lawyer. Talk like someone who is reading company law. So 1382. So for you to be appointed a company as an auditor, one, you must be qualified within the meaning of the Chartered Accountants Act, which establishes a regulatory body to manage auditors. And in that same regard, once you fall within the meaning, then it goes further to talk about, however, if you do not, and you find yourself under these provisions provided for under 1382 ABC up to H, then you do not qualify to be appointed an auditor of a company. So who is disqualified from being appointed an auditor? 1382A. Read to us.
Okay, Doc. A person is disqualified for appointment as an auditor if that person is A, an officer of the company or of an associated company. B, a partner of or in the employment of an officer of the company or of an associated company. Then
continue.
Okay. C, an infant. D, an infant found by a court of competent jurisdiction to be a person of unsound mind. Then E, a body corporate, except that a member of an incorporated partnership may be appointed in the manner provided by subsection 2 of section 139. Then F, one in respect of whom an order has been made under section 117, so long as the order remains in force, unless leave to act as an auditor of the company concerned has been granted by the court in accordance with that section. G, an undischarged bankrupt, unless that person has been granted leave to act as an auditor of the company concerned by the court by which the adjudication as bankrupt was made, or H, for the time being disqualified from acting as an auditor of a company by order of the registrar under subsection 4. Should I continue?
Yes, please continue.
Okay. 3. Paragraph B of subsection 2 does not disqualify a person from being appointed as an auditor by reason only of the fact that that person is a partner or in the employment of a person acting as company secretary of the company or of an associated company. 4. The registrar may, subject to a legislative instrument, disqualify a person otherwise qualified from acting as an auditor of a company and may at any time remove that disqualification. 5.
Okay. 5.
A person aggrieved by decision of the registrar under subsection 4 has a right to appeal to the court. 6. A person not qualified for appointment as an auditor who acts as an auditor commits an offense and is liable on summary conviction to a fine of not less than 325 penalty units and not more than 750 penalty units, and the company by whom that person is appointed and an officer of that company that is in default are liable each to pay to the registrar an administrative penalty of 750 penalty units.
And so there is also another instance by which the statutory provisions will lift the veil of incorporation. That is when you look on for someone who is not qualified to act as an auditor. And that person is unable to pay that or commits an offense. And once the person commits that offense, then the person who appointed, in that case, if you, the directors, appointed such a person who is not qualified, that is when the second part will also be applicable to you. So you can add it to instances where the veil of incorporation may be lifted. And that's when you make reference to Article 138, Section 138. So how is an auditor appointed? So the 139 describes the processes leading to the appointment of an auditor. Then the 140 talks about the remuneration. And that is when you can see different persons pays the auditor. And so the remuneration of an auditor shall be fixed where the auditor is appointed. So if by the directors for the period expiring at the conclusion of the next annual general meeting, by the registrar, or at a meeting of the company, and then it goes on and on and on until we get to how the auditor is removed under 141. Then we can talk about the functions of the auditor under 142. And 143 talks about how the auditor should avoid conflict of interest. So let me pause here. You have a lot to do, my people. That is all that auditors are supposed to do. And so my people are supposed to do a lot of reading. We've spoken about the qualification. We've spoken about the appointment of an auditor. And we can also talk about the remuneration of an auditor. And so the first, as and when you appoint, that is when you determine. But when Companies Act is making reference to an auditor, we are referring to an external auditor and not an internal auditor. So take notes. Company law Internal auditors are unknown to company law. We rather make reference to external auditors. And external auditors are to be appointed by the members because the auditor is supposed to report to the members. But it is a requirement for registration. And so that is why they talk about that the first auditors will be appointed by the directors. But that appointment is supposed to last to the next general meeting, after which the members will then decide whether to continue with that auditor or appoint another person. Where you do not have an auditor, the registrar can appoint one for, I think, with a period of 3 months or so. And at the annual general meeting of the company, you can pass a resolution to appoint an auditor. And that is what the 140 was talking, 140 talks about. And prior to your appointment, you must consent in writing, make some disclosures, and so forth and so forth. And so the remover is under 141, as we indicated. You cannot just remove the person without giving the person the fair hearing. And so if you want to remove, the resolution to remove the auditor the resolution to remove the auditor or to appoint any other person in place of the auditor is not effective unless notice of it is also given to the company of your intention. And before the general meeting, they have to acknowledge receipt, and they have to also send a copy of that intention of yours to remove the auditor to the auditor for him to also respond. And the response of the auditor must also be circulated to members so that at that meeting, members can make an informed decision. That is and this is in conformance with the right to fair hearing of Article 19 of our Constitution. Are you okay? So,
Yes, Doc.
the notes. So I have done my part too. We can even add directors to it this morning. But that one will take, so next week we can do that of the directors. You do the constitution of the company, then we can look at directors and add other things to it. And then you take that from there. Okay. If you have
Yes,
a
Doc.
question, if you have any question, ask.
Okay, sir. So, sir, in an attempt to remove an auditor, let's say I'm an organization, I
You are a
have the
company.
right to, I'm a company. Sir, I have the right to change my auditor. The auditor hasn't done anything though, but I want to change my auditor. I
You
can do
see,
so.
I'm coming. In company settings, here you are confused with internal auditors and external auditors. What we are referring to is external auditors. And in a company setting, you must have an auditor. And that auditor is for purposes of making a pronouncement on how the directors have used the resources entrusted in their care by the members or the owners of the company. So in this regard, you cannot unilaterally remove the external auditor. For the internal auditor, they report to you, management. They report to the directors as to whether management who ensure the day-to-day activities of the company are doing so as required by them, as directed by the directors. So the scenario you are bringing in, if you are referring to internal auditor, you can remove them at will. But if you are referring to a company setup, whether private or public, for you to remove an auditor, you have to go through the process. And that is the process outlined under Section 141 of Act 992. Please, do you get it? And remember that as a director, the auditors are not your your appendages. They are rather the appendage of the members. And they are supposed to report on you, the director, whether you are using the resources entrusted in your care the way it ought to be used or not. Are you okay?
Yes, sir.
Okay, so I think we can. That helps us in addressing this concern. Is there any other thing that you want me to address? Mm-hmm. Class, is there anything
Yes,
you want me
Doc.
to address?
Yes, Doc. Please, I want us to
Mm-hmm.
go back a little. Concerning the company secretary,
Mm-hmm.
yes, can an individual apply as a secretary in a company, or the company will have to liaise with a company that breeds professional secretaries so that the company will be given one?
Oh, check the 2113. Let's
Okay,
go
Doc.
back to section 2113. Who qualifies to be appointed a secretary? Yeah. So the qualification, you can be an individual provided you have obtained the requisite knowledge and experience to perform the functions of a company secretary. It is one of the requirements. So you can apply on your own, provided you meet the criteria mentioned under 3.
Okay, thanks, sir.
Are you okay?
Yes, sir. Yes, sir. When you're treating that, my network was misbehaving, so I
Okay.
couldn't get it very clear. Thanks very much.
Okay.
Say,
Yes, please.
say, let me find out this one. Oh.
Uh-huh.
The 2113.
Yes, please.
We have 2111. The two,
Mhm.
they are all separate issues. Then when you
Yes,
come to the 3, we have the
yes,
A, B, C, D, E. Is
yes,
it that
please.
when you are cognizant with, or you are okay with one point, like A, that you qualify, or you have to meet all the requirements
No, no,
under
no, 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 no.
the 3?
No. Okay, so this is it. The law says that you must have a company secretary and that you must possess the qualification. It did not say the qualifications. So if you are to be appointed a secretary, then you must have a qualification, the qualification specified. And A says that have you obtained a professional qualification or a tertiary level qualification that enables you to have the requisite knowledge and experience to perform the functions of a company secretary? If the answer is yes, you qualify. Have you held an office before the appointment as a company secretary trainee or has been articled under the supervision of a qualified company secretary for a period of at least 3 years? That is, if, for example, I have worked under a company secretary and I've worked under the person, understudied the person for not less than 3 years, I qualify to apply on my own. And I have to provide evidence of me working under a qualified trainee secretary for that period of 3 years. And then it goes on and on. Understood?
Yes, sir.
Okay. What again? Please, what again? Is there any other question you want me to know? Please, is there any other question you want me to know? Hey, my people, we don't want to talk.
Say we are here.
Is
We
there
are
any
here.
other question you want me to answer?
Okay, so let me ask this one. Fine, for my side, fine, and let me ask this one. So, say the company secretary, the required courses, let's say the person has to go through. Which type of courses?
So you see, when you read the 4, it says a professional or a tertiary level qualification is a discipline with an offering in company law, practice, and administration. So if the professional training that you went, which is offered at the tertiary level, there's an element of company law, like what you are currently doing. And
Okay.
there's company law, practice, and administration in it. It makes you qualify. Like the old structure of the Bachelor of Management Studies that UCC used to roll out some time back, or the current structure of Bachelor of Commerce Management, where you go through administrative law, you go through contract, you go through company law, and you go through business communication and other related activities, which trains you on how to write minutes and all, law and procedure of meetings and the rest. Once you've gone through this, per what is under subsection 3 of 211, you have met the requirement to qualify to be appointed the secretary, because in that case you have obtained a professional qualification or a tertiary level qualification, and in that tertiary level qualification you have the requisite knowledge and experience to perform the functions of a company secretary. That's all.
Okay, thank you, sir.
You are welcome. So we can, I think it's just a few minutes left. Today we have covered a lot within these 2 weeks. We have covered a lot. I'll plead with you to take time off and go through. The assignment that I've given, if in our next meeting I ask and you're able to provide me with the questions concerning the cases, you have +5 of marks that I'll put somewhere. And at the end of the computation of your marks, I'll add these 5 marks to it. So please, let's try as much as we can to read and do something small. And the areas that I have said I'm going to ask you the questions on are the areas I'm going to ask the questions. So let's try as much as we can to read, answer those questions. And it is part of the preparation to prepare us and make us ready for the end of semester, which is coming up shortly. Because once the semester has begun, your end of semester keeps drawing closer and nearer. If there are no other questions to ask, I will thank you for your patience, and I will also thank you for your contribution. Those who have been reading, helping in reading the acts, I do so that you become conversant with some of them. It is not a punishment. It is just a way for you to become conversant with it and be okay with the act that regulates the course that you are undertaking. Have a wonderful weekend. And those of you who support the EPL teams, I pray that all those teams playing over the weekend, you all lose. After all, Liverpool that I support have won. So the rest, I pray that you all lose. All the best and enjoy your weekend.
Thank you, Doc. Doc, we also pray for our team to win. Oh. We also pray for our team to win.
So I have done mine. God has listened to mine. So my other prayer is that God, let anybody who supports Arsenal lose. Anybody who supports Man U lose, and the rest.
Hey.
Have to do your prayers.
Okay.
And
we
the first
never comment. When our prayer is also answered, then we also talk.
Then we can also talk. For now, my prayer has been answered, so I can talk.
Next week we will give you our results next.
No problem. No problem. Enjoy the day and have a wonderful weekend.
Thank you, Doc.
Okay.
Thank you, Doc. We appreciate.